Fundamental rights and overview. Introduction. A fundamental right is one which is protected and guaranteed by the written constitution of the state. These are called fundamental because ordinary rights may be altered by the legislature in its ordinary process of legislation, but fundamental right being guaranteed by the constitution cannot be altered by any process than required for amending the constitution itself. Neither it can be suspended or abridged except in the manner laid down in the constitution itself. Further, they are most essential for the attainment of full intellectual, moral and spiritual life of an individual stunted and its potentialities are underdeveloped. Fundamental rights are deemed essential to protect the rights and liberties of the people against the encroachment of the power delegated by them to their government. Thus, we can say the fundamental rights being guaranteed by the fundamental law of the land. No organ of the state, that is executive, legislative or judicial, can act in contravention of such rights, and any such act which is repugnant to such rights will be void to the extent of repugnancy. So we have a case over here. The name of the case is A.K. Gopalan versus State of Madras, All India Report 1950, Supreme Court 27. In this case, Chief Justice Patanjali Shastri observed that the insertion of fundamental rights in the forefront of a constitution, coupled with an express prohibition against legislative interference with these rights and the provision of constitutional sanction for the encroachment of such prohibition by means of judicial review, is a clear and emphatic indication that these rights are to be considered paramount to ordinary state-made laws. And now we are moving on towards the second case, that is Menka Gandhi versus Union of India, 1978, 1 Supreme Court cases 248. In this case, it was observed that the fundamental rights represent the basic values cherished by the people of this country since the Vedic times, and they are calculated to protect the dignity of the individual and create conditions in which every human being can develop his personality to the fullest extent. They weave a pattern of guarantee on the basic structure of human rights and impose negative obligation on the state not to encroach on individual liberty in its various dimensions. Fundamental rights are regarded as fundamental because they are the most essential for the attainment by the individual of his full intellectual, moral and spiritual status. These fundamental rights help not only in protection but also in the protection of gross violation of human rights. Another case we are having over here is M. Nagaraj versus Union of India, 2006, 8 Supreme Court cases 212. In this case, the Supreme Court observed that fundamental rights are not gift from state to its citizens. Individuals possess basic human rights independently of any constitution by reason of basic fact that they are members of the human race. These fundamental rights are important as they possess intrinsic value. Part 3 of the Constitution does not confer fundamental rights. It confers their existence and gives them protection. Its purpose is to withdraw certain subjects from the area of political controversy and to place them beyond the reach of majorities and officials and to establish them as legal principles to be applied by the courts. Every court has a content. Every foundational value put in part 3 as fundamental right has an intrinsic value. The converse does not apply. A right becomes a fundamental right because it has a fundamental value. nature and scope of fundamental rights. The fundamental rights guaranteed in the Constitution of India are characterized by certain features which are as follows. First, the fundamental rights are universal, that is, they are applicable to all the citizens of India, irrespective of caste, color, creed, gender, and religion. For example, Article 15, 16, 19, 29, and 30 are the fundamental rights which are exclusive to the citizens of India, and Articles 14, 20, 21, 21A, 23, 24, and 25 to 28 are the fundamental rights which are applicable to any person living in India except to the enemy lines. Second, the fundamental rights are individual rights and are enforceable against the state and not against individuals except right against untouchability. Article 17. Right against exploitation. Article 23 and 24. And right to personal liberty. Article 21. Where an individual can be taken to the court of law in case of violation. Case. People's Union for Democratic Right versus Union of India. All India Report 1982, Supreme Court 1473. In this case, Supreme Court held that whenever a fundamental right contained in Articles 17, 23 and 24 is being violated by a private individual, it would be a constitutional obligation of the state to take necessary steps to interdict such violation to ensure that such person should respect that right merely because the aggrieved person could himself protect or enforce his invaded fundamental right. Do not absolve the state from its constitutional obligation. Third, fundamental rights has both negative and positive aspects. Some fundamental rights impose restrictions on the actions of the state, that is, they mandate state not to do a particular type of act, like Article 14, which embodies that the state shall not deny any person equality before the law. In the same manner, similarly, Article 15.1, 16.2, 18.1, 20, 21, 22.1 and 28.1 are some other fundamental rights which impose restrictions on the state. Therefore, they can be said to constitute negative rights. On the other hand, some fundamental rights directly confer rights upon the citizens of India, without even containing any provision relating to the actions of the state, like Article 19.1, which embodies that all citizens have the right A. to freedom of speech and expression, B. to assemble peacefully and without arms, etc. Similarly, Article 21A, 25.1, 29.1 and 31 are some fundamental rights which directly confer rights on the citizens. Fourth, most of the fundamental rights are self-executory and does not require any legislation to enforce them. But there are certain fundamental rights which require further legislation to make them enforceable. For example, Article 17, Abolition of Untouchability. Parliament enacted Untouchability Offences Act 1955, which was renamed as Protection of Civil Rights Act 1955, and Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989 for enforcing Article 17. Article 21A, Right to Education. Our Parliament enacted the Right of Children to Free and Compulsory Eviction Act 2009 for enforcing Article 21A. Article 23, Prohibition of Traffic in Human Beings and Forced Labour. Our Parliament enacted Suppression of Immoral Traffic in Women and Girls Act 1956, which was later renamed as Immoral Traffic Prevention Act 1956 for enforcing Article 23. Article 24. Prohibition of employment of children in factories or etc. Parliament enacted the Child Labour Prohibition and Regulation Act 1986, the Employment of Children Act 1938, the Children Pleading of Labour Act 1953, the Indian Factories Act 1948, the Mines Act 1952, the Merchant Shipping Act 1958, the Motor Transport Workers Act 1951, the Plantation Labour Act 1951, the Beedi and Cigar Workers Condition of Employment Act 1966, and the Apprentices Act 1961, etc. for enforcing Article 24. Fifth, the provision of Article 14, 15, 16, 18 and 29 to embody the quality of principles. On the other hand, Articles 19, 20, 21, 22, 25, 26, 27 and 28 embody the liberty principles, while Articles 15 to 17, 21A, 23, 24, 29 and 30 embody the principles of equality as well as liberty. Sixth, every fundamental rights provided under Constitution are not absolute, and Constitution imposes certain limitations on its exercise. For example, Article 19 guarantees to all citizens freedom of speech and expression, but citizens are required not to utter anything which may affect foreign relations. Similarly, Article 16 provides for equality of opportunity for all citizens, but the state has been empowered to make reservation in appointment in favor of scheduled castes and scheduled tribes. However, some of the rights are absolute. These rights are right against untouchability, Article 17, right against engaging children below 14 years of age in hazardous units, Article 24, right to freedom of conscience, Article 25(1). Classification of fundamental rights. So the Indian Constitution guarantees 6 types of fundamental rights. First is right of equality, which is Article 14 to 18. Article 14, equality before law and equal protection of law. Article 15, prohibition of discrimination on the basis of caste, creed, gender, religion and place of birth. Article 16, equality of opportunity in public employment. Article 17, abolition of untouchability. Article 18, abolition of titles. Second, right to freedom. Article 19 to 22. Article 19. A. Freedom of speech and expression. B. Assembly. C. Association. D. Movement. E. Residence. F. It was deleted through 44th Amendment. G. Choose profession. Article 20. Protection in respect of conviction for offences. 21. Protection of life and personal liberty. Article 21A. Right to education. Article 22. Protection against arrest and detention in certain cases. Third, right against exploitation. Article 23 and 24. Article 23. Prohibition of traffic in human beings and forced labor. Article 24. Prohibition of employment of children below 14 years of age in factories and hazardous employment. Fourth, right to freedom of religion. Article 25 to 28. Article 25, freedom of religion in India. Article 26, freedom to manage religious affairs. Article 27, freedom from taxes for promotion of any particular religion. Article 28, freedom as to attendance at religious instruction in certain educational institutions. Fifth, right to culture and educational minorities. Article 29 and 30. Article 29, protection of language, script, or culture of minorities. Article 30. Right of minorities to establish and manage educational institutions. 6th. Right of constitutional remedies. Article 32. Article 32 remedies for enforcement of the fundamental rights through the issue of certain writs by Supreme Court. First, habeas corpus. 2. Mandamus. 3. Prohibition. 4th. Quo warranto. 5th. Certiorari.